In this video, I'm going to summarise the 2025 case of Lando and Robin. This is a relocation case. So there were 3 children and mum unilaterally relocated with the 3 children to a different area. Dad commenced court proceedings seeking orders for the children to return to the area at which they were residing before the mother unilaterally moved away with the children. And he was successful. The judgment I'm going to read from is mum applying for a review of that decision that permitted or that approved the father's application and required the children to return to the area they were living. So let's take a look. This is the 2025 case of Lando and Robin. You can view the entire judgment for free using Ostley. These are not the parties' real names, they're pseudonyms. By way of background, it was a parenting matter concerning 3 children. Child X, who was 10, child Y, who was 7, and child Z, who was nearly 3 years old. So the judgment I'm reading from, the publicly available judgment, it's a review of orders made by Senior Judicial Registrar Nielsen. Those orders were made on the 28th of March 2025. Being a review hearing, it's a hearing de novo, meaning they hear all the evidence again and they decide the matter afresh, brand new. Since the hearing before the SJR in March, the parties have attended for a private child impact report with Miss H, which was dated 2nd of June 2025 and filed on the 5th of June 2025. The central issue for this review is the mother's desire to live in suburb B, which is an area of Sydney, where she unilaterally moved with the children in January 2025. Prior to the move, the mother lived in suburb C, another suburb of Sydney, where she and the father had resided since 2017. The Senior Judicial Registrar, SJR, made orders for the mother and the children to return to live in the suburb C area. The mother seeks to review those orders, which were stayed pending a review. The parties were in a relationship from early 2011 to March 2023. The care arrangements for the children during the relationship are in dispute. However, in about September 2024, the parents reached an agreement whereby the father would spend time with the children from Sunday morning until Tuesday each week. This was in line with his work arrangements as a community worker. In the early January 2025, the father endeavoured to increase his time with the mother, and he was unsuccessful. He informed her that he would be spending equal time with the children. On 7 January 2025, the father kept the children in his care for additional time without the mother's agreement. The mother attended to collect them, but eventually agreed to an additional night on that occasion. However, the following day, there was a further dispute between the parties that led to New South Wales Police being called. On 11 January 2025, the mother informed the father that she would be retaining the children in her care pending a court determination. She simultaneously signed a lease on a property owned by her partner in suburb B, and she moved to that location with the children shortly thereafter. The father then filed his application in this proceeding on 14 January 2025. The mother didn't inform the father of the children's whereabouts until 5 February 2025. The matter came before the SJR for an interim hearing on the 28th of March 2025, whereby orders were made for the mother to return with the children to suburb C area by 22nd April 2025. And then the mother filed a review of those orders on 2 April 2025. The same orders made by the SJR were stayed pending this review hearing. The court points out that an interim hearing is different to a final hearing. It says, being an interim hearing, the evidence has not been tested by way of cross-examination. At a final hearing, you have cross-examination of the parties and the witness. So at an interim hearing, other than in exceptional circumstances, there's no cross-examination. They're much shorter. Interim hearings are very different to a final hearing. So the court says, being an interim hearing, the evidence has not been tested. Each party argues there is reason to doubt the evidence of the other party. The mother says, for example, that the father has provided evidence of his parenting role which is inconsistent with his other evidence, whilst the father says the mother informed the children's new school of an ADVO which did not exist. For that reason, although I have regard to the matters in dispute, I have endeavoured, where possible, to rely on agreed facts and less contentious evidence, which is how the court generally approaches interim hearings, by relying on agreed facts and less contentious evidence. Pause to read. The court goes through section 60cc, which is how the court determines what is in a child's best interests. The mother says that she had to move when she did because of the father's coercive and controlling behaviour, which had become increasingly concerning. She says that in November/December 2024, the father's behaviour escalated to a point where she started to have grave fears for the safety and herself. The mother said that she wanted to move to Region O, where most of her support network reside. It is argued for the mother that the father's behaviour in late 2024 and early 2025 must be seen in the context of a history of family committed by the father. The father, for the most part, denies the family, although he admits to placing a tracking device in the mother's car when he suspected she was having an affair. In this regard, it is concerning that the father continues to try to justify his actions. I note that although he expressed remorse to Ms. H, he has never said this to the mother. Further to this, messages sent to the mother by the father indicate a disturbing attitude to the mother. For example, calling her to, and I quote, "keep spreading your herpes and leave the kids to me," end quote. The court says, however, even if I accept the mother's evidence in its entirety, there were other steps she could have taken to protect herself and the children from the father's behaviour, other than immediately moving to Region O in Sydney. I acknowledge the mother's evidence that she approached the police to obtain an ADVO in early 2025 and that the police did not take any action. However, the mother could have brought her own application. Otherwise, she could have filed an application for orders in this court, as she foreshadowed to the father on 11 January 2025. However, it appears she had already decided to move to Suburb B before any such application could be determined. There is also a reason to question the mother's bona fide, given that the mother asserts most of her support networks are in Region O, yet her parents live in Suburb C and her sister lives in Suburb N. The court says it is also concerning that the mother did not inform the father of her move until 5 February 2025, and that she did not include any information about the father when she enrolled the children in a new school. Indeed, for reasons that are unclear, the mother informed the school that there was a current ADVO in place, despite her own evidence indicating that the police would not take out an ADVO, and the court being informed that no ADVO was presently in existence. Neither party explained what the court was to make of the correspondence from a DV service, which indicates an ADVO was actually made in 2025 for 2 years. Either the mother had an ADVO relating to issues in Suburb P, which may have negated the need to move, or as per the mother's evidence, there was no such ADVO in existence, in which case she misled the school. The court says, I am unable to make a finding about these matters, but it again causes me to have concern about the mother's true motivations for her move to Suburb B. The next section in the judgment is titled Views of the Children. The mother's evidence is that the two eldest children, X and Y, are happy and have settled extremely well in the Region O of Sydney. Z is said to be thriving. The judgment says, however, contrary to this, senior counsel for the father referred to notes from parent-teacher interviews on or about 13 March this year, in which Y is recorded as stating, "I get sad because I don't get to see my dad." And in reference to what she likes to do in her spare time, she states, "See my dad." The mother made no reference to this in her affidavit sworn around that same time and did not raise it in the interviews for the child impact report. In the child impact report, it was evident that the two girls are mature and articulate. Z was not interviewed due to his young age, but it was clear he had strong bonds with each of the parents. In the child impact report, child X reported her preference was 45% to stay in Suburb B, but she would like more to return to Suburb C. She said she would not care about returning to her former school as she had friends at her former school. Child Y told Ms. H that she wished to return to her previous school. The judgment says, nonetheless, the evidence also suggested that the father has spoken directly to the children and involved them in the dispute. For example, child X made reference to the father having to sell their forever home, and child Y reported that the father told her that she would be returning to her old school in about a month. The father also appears to have had conversations with the girls, which he records as speeches, and which relate to their home and their relationship with the father. Child X reports that her mother is pretty nice to her father, but her father is rude back. It is also clear that the children have been exposed to conflict between the parties, with child X reporting memories of the parents arguing and describing being caught in the middle. This culminated in the incident on 8 January 2025, in which the police were called to attend the property. The court says at paragraph 36, for these reasons and because of their relatively young ages, I'm reluctant to place much weight on the expressed views of the children in this matter. Remember, children's expressed views are one of several factors the court will take into account. I commonly hear people get it wrong. They think that from a certain age, children get to decide their own parenting arrangements, which is not the case. Any expressed views by the children are maybe given weight, and more weight the older and more mature they are, but it's not determinative. It's not binding. Their expressed views aren't binding on a judge. In relation to the needs of the children, the court says that based on the evidence, both parents appear to lack insight into the emotional needs of the children. Each appears to have partaken in a form of tug-of-war over the children, with the father insisting on shared care and the mother ceasing all time between the father and the children and moving away. Neither parent acknowledged the impact of their behaviour on the children. Otherwise, the main issue concerning the children's need relate to child Z and his ability to cope with longer periods away from the mother. This was not something the father appeared to have any insight into, proposing orders that the older girls and Z could simply move to live primarily with him if the mother did not wish to return to suburb C. In doing so, the court says, he fails to acknowledge that Z is only 2 years old and that Ms. H recommended a gradual increase of time. In relation to the benefit of the children having a relationship with their parents and other significant people, the court said the parties each assert that it is important for the children to have a relationship with the other parent and extended family. Whilst the mother asserts that such relationships can be maintained with the children residing in either suburb B or C, the father argues that the mother unilaterally moved to suburb B to eliminate his relationship with the children, or in total disregard of same. The court says it has called into question whether the mother is bona fide in that respect, and the court said it is unable to make a finding at an interim hearing. Freedom of movement is something that is considered in relocation cases because adults have a constitutional right to freedom of movement. So the court considered freedom of movement. It quotes Justice Kirby in the seminal case of AMS and AIF as follows: the applicable legislation is enacted and the relevant discretions exercised for a society which attaches high importance to freedom of movement and the right of adults to decide where they live. That is doubtless why courts have expressed themselves as reluctant to make orders which interfere in the freedom of custodial or resident parents to reside with the child where they wish, at least where such parent is the unchallenged custodian or has been designated the sole guardian of the child. One of the objects of the modern family law statutes is to enable parties to a broken relationship to start a new life themselves, to control their own future destinies, and, where desired, to form new relationships, free of unnecessary interference from a former spouse or partner or from a court. That said, the touchstone for the ultimate decision must remain the welfare or best interest of the child, and not, as such, the wishes and interests of the parents. So a parent doesn't have to prove or demonstrate compelling reasons for the relocation. They have to demonstrate why their proposal to relocate with the children is in the children's best interest by applying the considerations as set out in section 60cc of our Act. And the court will generally consider each of the parents' proposals. Often you might have a primary position. If I'm allowed to relocate, this is my position. If I'm not allowed to relocate, this is my position and my proposal. The court considers all of the proposals when deciding which proposal is in the child or children's best interest or which arrangement is in the child or children's best interest. I argued that her proposal is in the children's best interest because she would be happier, and it's the location she clearly wishes to live, and she'll be closer to or living with her current partner. The children would not have to go through yet another change of housing, at least in the short term, noting the mother plans to move in with her partner and schooling. The disadvantage in relation to the mother's proposal is that the children would only be able to spend time with the father on alternate weekends and potentially a midweek dinner, although it is unclear if that is sustainable given the travel time for the father. The children would also possibly miss out on the father being able to just drop in to school and or extracurricular activities, and may miss out on attending play dates with friends if they're spending time in suburb C with the father. The children would also not have the benefit of their grandparents living only 10 or 15 minutes away. The father's proposal. The advantage of the father's proposal is that the children would be able to spend significant time with both parents. Each parent would be able to participate in formal and informal school events, extracurricular activities, and facilitate playdates, birthday parties, and the like. The children would also be residing in close proximity to both the maternal and paternal grandparents. The disadvantages of the father's proposal is that the mother is likely to be unhappy at having to return to live in suburb C area, where she says she has been ostracized due to the actions of the father on social media. This may have a flow-on effect for the children. The mother may also have difficulty acquiring rental accommodation, although the court says she was previously able to obtain rental accommodation in that area. The court analyses the applicable law from paragraph 47. It points out the difference between the purpose of an interim hearing compared to a final hearing. And it says this at paragraph 47. Interim disputes should be confined to only those issues which, in the best interest of the child, require determination prior to a proper determination at trial. The trial is the time and place to settle factual controversies, because remember, you can cross-examine at a final hearing. Interim hearings ought not be used for that purpose unless circumstances are urgent and there is no alternative. So at an interim hearing, you think about what orders are urgent and there is no alternative. You need to seek them at an interim basis. The court cites the seminal case of Morgan and Miles, and Morgan and Miles is often cited by people resisting the relocation at an interim hearing. And it quotes Morgan and Miles as follows. In Morgan and Miles 2007, the full court said the following at 88. It is highly desirable that, except in cases of emergency, the arrangements which will be in the child's best interest should not be determined at an abridged interim hearing, end quote. The court says at 49, on this basis, it could be argued that the children should stay where they are pending a final determination. However, it cannot be ignored that the mother unilaterally relocated, knowing the father did not agree and without informing him for almost a month. The father issued proceedings as soon as he could, and the matter was heard expeditiously. Through no fault of the father, the matter has taken until now for those orders to be reviewed. The court cannot condone a party taking such unilateral action. There are proper processes that should be followed, and the mother ought not benefit from the system that has resulted in a 5-month delay. Having said this, the best interests of the children remain the paramount consideration. In terms of the best interests of the children, the mother does not say that the children are currently at an unacceptable risk of harm in the father's care. Indeed, the orders proposed by the mother are not consistent with any such risk. Although the parents are in dispute about the amount of time each child has spent with the father on any version, he has spent substantial time with them post-separation, and the parties agreed in late 2024 that this would be 2 nights each week. Ms. H reports that the children have a strong bond with each parent, and it is reported both in the child impact report and the parent-teacher interviews that the girls miss their father and want to spend more time with him, more than the current arrangements allow and more than is arguably practicable given the distance between the 2 locations. Nonetheless, the court says, I must consider the impact on the children of moving back to suburb C, particularly in circumstances where the court may, at a final hearing, ultimately permit the mother and the children to live in suburb B. In this regard, it is significant that the children have spent most of their lives in suburb C, the Q area, and only 5 months in suburb B. The court notes that even on the mother's own evidence, her current living arrangement is only temporary. She plans to move in with her current partner in Jan 2026. The court says suburb C is still very familiar to the children, and the comments of the children in the CIR indicate they miss their friends and former school. Child X, who is now grade 5, and Y, who is now grade 2, have spent all of their school prior to January this year at school D in suburb C. Indeed, the mother, in her earlier affidavit, stated she was reluctant to move them from school D due to the disruption they would face. Determination. On balance, I find that any impact on the children of a return to suburb C will be offset by the strong bond they have with each of their parents, their friends at D school, the community that is familiar to them and suburb C, and the close vicinity of both parents, the maternal and paternal families. Whilst a move back to suburb C will require the mother to break her current lease and find a rental property in suburb C, this is a situation of her own making. I note she had rental accommodation in suburb C and chose to break that lease, and that her current lessor is her partner. The father has also filed evidence of a significant number of possible rental properties in the suburb C area, which he says are available to the mother, and points out that the mother is currently paying rent at a higher rate than she was paying previously in the suburb C area. For all of the aforementioned reasons, the court proposes to make orders sought by the father that the children return to suburb C by 11 July 2025. The court did not make the orders that the children live with him in the event that the mother herself does not return. The mother in her case outline puts her case on two bases. Either she lives with the children in suburb B or she lives with them in suburb C. No submissions were made that the mother would remain in suburb B if the court ordered the children's residents should return to suburb C. Accordingly, the court need not consider whether she should personally be compelled to return to the suburb C area. This is a really interesting judgment because it explains the difference between the purpose of an interim hearing and interim orders and a final hearing and final orders. At 47, the court says, interim disputes should be confined to only those issues which, in the best interest of the child, require determination prior to proper determination at a final hearing. The trial, the final hearing, is the time and place to settle factual controversies, because at a final hearing, there's cross-examination of the parties and the witness. At an interim hearing, there is not. And of course, evidence that has been tested by way of cross-examination is more reliable than evidence that has not been tested. The court says interim hearings ought not be used for that purpose unless circumstances are urgent and there is no alternative. And again, as Morgan and Miles says, and as quoted at paragraph 48, it is highly desirable that, except in cases of emergency, the arrangements which will be in the child's best interest should not be determined at an abridged interim hearing. It's important to understand the difference between an interim hearing and interim orders, and a final hearing and final orders. As always, the content of this video is a single case summary. You should not rely on the content of this video as legal advice. If you're going through a separation, it is very important to obtain legal advice that is tailored to the unique factual circumstances of your matter. Small factual changes can impact the advice and the outcome that you receive.